Hello, hello. Welcome back. My name is Carly Jones, and I'm an employment attorney at the Manifest Justice Law Corporation. Today, we are going to talk about some of the most commonly used legal jargon that attorneys throw around. Because we assume that, we rarely take the time to stop and explain what we're saying when we use these terms, and clients don't always ask questions. I want to make sure that everyone understands these commonly used terms before we get too deep into this channel and we're making like super niche employment law content. So, the first terms that I want to make sure that everyone knows and that every single attorney is going to use commonly, frequently, and we are definitely assuming that you know what these terms mean: plaintiff and defendant. So, the plaintiff is the person who brings the lawsuit, it's the person who is suing, it is the person who is claiming that they have been harmed and that they have endured some kind of legal violation. They're seeking recovery for their rights. So the plaintiff is the harmed person. The plaintiff is the person who is suing. The defendant is the person who is defending themselves from the lawsuit. The defendant is the person who's being sued. They have to defend against the lawsuit. They have to show why they didn't violate the plaintiff's law, why they didn't violate the plaintiff's rights, and how they are not liable for the plaintiff's damages. So the defendant is defending themselves. They are the person who is being sued. So in an employment law context, the plaintiff is very typically, it's the employee or former employee who was harmed. It's a contractor or former contractor who, again, was harmed. It's a job applicant sometimes, an intern perhaps, but it's the person who had a working relationship. It was the person who was harmed on the job. The defendant, typically in an employment suit, the defendant is the employer. So the company, the bosses, the supervisors, the managers, HR perhaps, but it's the company. It's the company, it's the employer who hired, who does the hiring, and who was responsible for ensuring that the plaintiff didn't get harmed. So if that's not clear, leave me a comment, let me know. I will do more explaining. The other thing that I wanted to make sure people understand the difference of is the difference between civil court and criminal court. So in employment law, we are bringing civil claims. Civil court is for people suing people, people suing businesses, businesses suing businesses, businesses suing people, etc., etc. It's for the people, brought by the people, upon the people. A criminal court involves government. It involves like the police, it involves FBI, it involves the prosecutor's office, the DA, the district attorney. It involves investigators, it involves multiple people, but it involves criminal charges, and it typically means you're going to go to jail. It's going to be jail or prison is the typical punishment when you're in criminal court. Sometimes there will be additional fines, but most of the times, and like sometimes there'll be like community service. Sometimes there are different repercussions or orders that a defendant would have to tend to in criminal court. But usually the punishment in criminal court is jail time or incarceration of some sort. In a civil matter, typically the punishment is money. It can be also an injunction or a kind of an order to stop someone from doing something or force someone to do something. So there can be an order to do something or to not do something, but typically it's money. Typically, it's money and money getting paid back. Again, sometimes there's property involved in both civil and criminal, but typically it's jail time is the penalty for criminal court and money is the penalty for civil court. Another difference is that in civil court, we have claims and we have causes of action. These are the laws that have been violated and that we're suing under. These are the claims that we're bringing forward. We're claiming that this law was broken. The cause of action is that this law was broken. And in criminal court, we don't have claims and we don't have causes of action. We have charges. You're going to be charged with a crime, right? You're going to be charged with homicide. You're going to be charged with battery. You're going to be charged with kidnapping. You're going to be charged to go to serve, again, an incarceration term. And this is going to be a claim for money, a cause of action for money. There are situations where there are crimes in criminal court, and then there are also similar laws in civil court that mirror what's going on in criminal court. And this is so that citizens can sue each other, or citizens can sue businesses, citizens and entities can sue each other, and we're not just relying on our government. So as we know, there are plenty of times where the government doesn't take action. And so the civil court is available for another means to recover. So for example, rape cases, we know that like less than 10%, I think it's even less than 1% of rape cases that are reported actually go through, are charged, and someone goes to jail. So in those situations where someone is not charged, where there's not a trial, or where someone is acquitted and they don't end up going to jail, there are also rape statutes and sexual assault statutes in civil court, so that family members or the harmed person can then follow up on those charges in civil court. The difference between criminal court and civil court is that there's typically a lesser burden to prove, easier to prove your claims in civil court than it is in criminal court. And in criminal cases, you have to prove your case so much that like all the jurors. So the difference is that in criminal court, there's a higher burden of proof, which means it's harder to prove your claims than in civil court. In civil court, you have to prove that like it's more likely than not that this happened. And in criminal court, you have to prove beyond a shadow of a doubt this has happened. There's no reasonable doubt here. This has happened. So it's much harder to prove in criminal court than it is in civil court. And also in criminal court, the district attorney, the DA, decides who's going to bring the charges and if they're going to charge the suspected criminal in that situation or not. And in civil court, it's the people who are harmed who decide if they're going to bring a claim or not. So we've got the plaintiff is the person who's sued, the defendant is the person who's being sued. Civil claims are for people suing each other, or people suing businesses, or businesses suing people. And criminal court is for the government to charge individuals charged with a crime. In criminal court, the plaintiff is always the government. It's always a prosecutor. It's not a plaintiff, it's a prosecutor. And the defendant is always going to be the person who's being charged with the crime. In civil court, the plaintiff is going to be the person who's actually harmed, or the family members or bystanders who are directly harmed from a situation. And the defendant's going to be the person defending themselves. Some other terms that are really important in an employment law context specifically are the difference between employee, independent contractor, and employer. So the employer is the person who hires, and it's the person who gives the money and is giving the job. The employee is the person who is taking the job, receiving the job, is the worker, is the employee, is a worker. An independent contractor is someone who is not employed on a like routine, consistent, maybe regular long-term basis with a company. They are not a full employee. They probably don't receive benefits. They have complete control over how they do the job, typically when they do the job, which tools to use the job. So an independent contractor and an employee are typically differentiated by the amount of control that they have within their job titles and roles. But we've also recently gotten new judgments on how to differentiate between an employee and an independent contractor. So I'm going to make another video about that goes into it in depth. But just for a broad overview for this video's sake, to understand the key terms, an employee is different from an independent contractor, and both of those, an employee and an independent contractor, are different from an employer. Okay, but you will hear those terms commonly in employment suits. Another term that's really common in employment suits is meet and confer. So the meet and confer is a stage in a lawsuit where it's basically a requirement that before, and it depends on your jurisdiction. Sometimes it's a hard requirement that each party must meet and confer. Sometimes it's just a recommendation and a like soft nudge, but it's a rule or requirement or expectation that parties will meet and confer, which means they'll meet and talk about the lawsuit before a lawsuit's filed or before we actually go to trial for a lawsuit. It's basically saying we have tried to reach out and we have tried to resolve this issue before we ask for court intervention. The reason why meet and confer is such an important step in a lawsuit is because, as I said, there are so many legal harms. As I've said multiple times on this channel, there are so many legal harms that occur in this country, and especially in this time. Like, there are so many violations that even if you wanted to sue someone right now today in civil court, you're probably not going to get on the calendar until next year. I mean, depending on the type of law, depending on your location, but courts are really jammed up, and some courts are still even dealing with the backlog. Some courts are even still dealing with the backlog from the pandemic times. Some courts are still backed up from the lockdown pandemic of 2019, 2020. And so fairness and efficiency is one of the main pillars of courts. If you are being inefficient by wasting the court's time and bringing frivolous lawsuits that could have been settled outside of the court without court intervention, then that has like a very damaging impact on our reputation as attorneys attorneys, but also on the legal claims that we're bringing on your behalf. And so we want to make sure that we meet and confer with the other side before we actually file a lawsuit or are like asking again for court intervention. So that's a stage in the lawsuit, meet and confer, which maybe I'll do another video talking about the different stages of an employment lawsuit so that kind of everyone has an understanding of the arc and the timeline. Let me know if that would be helpful. I will make another video with more terms that are commonly used in employment law settings, and you will see it soon and we won't have all these stripes to play with. If any of the terms that I've talked about so far today, defendant and plaintiff, criminal law versus civil law, employee versus employer versus independent contractor, and meet and confer, if you have questions about any of those terms, please, please, please drop a comment below, let me know, and I will do my best to make a video ASAP and either re-explain or answer your questions. If you found this video was informative, was empowering, or like may help you get paid, I want to know that too. So please drop a comment and let me know, give me a like, or you can share this video with your network and hopefully empower and inform some other folks. Okay, everybody works. Not everyone is safe at work. I am here to help you know the difference. Okay, I hope this was helpful. I'll talk to y'all later. Bye.